everybody to the meeting on June 25th of the Clearinghouse on Women's Issues, Changes and Challenges in the 2024 Title IX Regulations. The meeting is going to be moderated and introduced by Jeanette Esbrook, who's a former Assistant Secretary of the Office for Civil Rights in the U.S. Department of Education, who knows a great deal about Title IX and its history. Welcome, Jeanette.
Representing the United States as a Department of Justice attorney. I was the OCR policy director overseeing the implementation of Title IX, its regulations and policies. Title IX was enacted in 1972, 52 years ago. And the Title IX implementing regulations were published in 1975. 1975 was a banner year for women. Some of you may remember that period as the second, or sometimes called the third women's movement. In 1972, the first issue of Ms. Magazine was published. Recall that Helen Reddy's I Am Woman, Hear Me Roar was at the top of the music charts. The children's book, Free to Be You and Me, by TV star Marlo Thomas, was published. The Senate approved the Equal Rights Amendment. President Nixon signed Title IX, and in January of the following year, the Supreme Court decided the landmark abortion case, Roe v. Wade. 52 years later, only one of these rights of women remains standing, only one, and that is Title IX. Sobering thought, isn't it? But it is our challenge. Title IX provides, in 37 words, no person in the United States shall, on the basis of sex, be excluded from participation, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. While Title IX is well known for, and there are numerous headlines, and the interest tends to identify Title IX with athletics and sexual harassment, let's remind ourselves of the initial purpose of Title IX. It was passed as a component of the Higher Education Amendments in 1972. Title IX's purpose was to guarantee equal education and employment opportunities for women and girls by recipients of federal financial assistance, not unlike Title VII. One of the early Title IX cases was, in fact, access to the University of Chicago Medical School, where a successful case was made on the denial of admissions to Geraldine Cannon because of discrimination based on her gender and on her age of 39 years old. They thought that was too old for medical school. Today's topic of the 2024 Title IX regulations are a reinstatement and an important component of these rights that are guaranteed under Title IX. Here's a brief history of one of the issues, and that is the early development of Title IX sexual harassment policy. In 1981, I was a newbie attorney in OCR, and given an initial assignment to analyze, address, and assist in the investigation of one of a new type of Title IX complaint, which OCR had been receiving. Keep in mind that in 1981, the term sexual harassment had not come into common usage as it is today. Other departments such as labor, justice, the EEOC were also dealing with this issue. At OCR, this student filed a complaint to our Denver office. She complained that the financial aid officer at a university required her to sit on his lap while he acquired information about her eligibility for a student loan or a scholarship. This apparently was his practice or standard operating procedure for all female students. Based on 1979 cases in colleges, Price v. Yale and Alexander v. Yale, in which students had successfully sued that their course grades were diminished because each had refused the overture of the professor's sexual come-ons. In addition, I had learned and was aware at higher education institutions at which I worked that practices of this nature were accepted or looked upon the other way. So with all this in mind, I began to draft a legal memorandum and an investigative guidance. The document, after the typical level of reviews that occurs in federal agencies and edits, eventually became the first OCR policy memorandum to OCR's 10 regional office at that time in August of 1981. In the investigative policy memorandum, OCR reaffirmed quite specifically that its Title IX jurisdiction over sexual harassment complaints was real and adopted the following working definition of sexual harassment. Sexual harassment consists of verbal or physical conduct of a sexual nature imposed on the basis of sex by an employee or agent of a recipient of financial aid that denies, limits, provides different or conditions the provision of aid, benefits, services, or treatment protected under Title IX. Since 1981, OCR has experience based on complaints, investigations, and letters of findings of sexual harassment, and numerous athletic cases like the abusive Larry Nassar at Michigan State examination of women gymnasts and Ohio State men's wrestling team abuses. And informed by the Me Too movement, OCR policy began to include a more complete understanding regarding the rights of all parties, safety concerns, began to accept and believe survivor statements, and how men and boys can also experience harassment. In addition, there have been numerous notorious cases, including the Weinstein and Jeffrey Epstein cases concerning sexual harassment, which have led to a better common understanding of how sexual harassment involves power, intimidation, and violence. These were difficult issues to initially understand, investigate, and make discrimination findings. But we began to litigate and over time to develop regulations and policies that could inform our investigations, resulting in fairness, respect, and equal treatment determinations. Unfortunately, under the Trump-DeVos leadership, new sexual harassment regulations were promulgated that minimized or even obliterated rights that were developed over a 50-plus year time. The purpose of the 2024 regulations we are addressing today reestablish, as I've said, these Title IX and equal protection rights, as well as to provide and strengthen others, including protections for LGBTQ plus individuals and coverage over pregnancy and parental status. The final athletic Title IX regulations has not been published. We shall learn more today from today's speakers. And after all their presentations, we will have a Q&A session where both presenters and participant viewers will have an opportunity to question and to comment. The chat option on Zoom will be monitored for questions by our Vice President, Jan Erickson. Let me introduce our first speaker. Rebecca Amadi is the Federal Policy Manager of GLEASON, the Gay, Lesbian, and Straight Education Network, which works to ensure that LGBTQI plus students are able to learn and grow in a school environment free from bullying and harassment. Rebecca will describe the justifications for and objections against the non-discrimination provisions relating to gender identity and sexual orientation in the 2024 Title IX rules and regulations. She will discuss why they were included in the regulation, including the Supreme Court Bostock decision, what they cover, and why the promised Title IX athletic rules have not been released. Then she will describe LGBTQI plus supporters' actions to implement the new Title IX regulations. I turn this over now to Rebecca.
Thank you so much, and thank you to everyone here. Really excited to talk to you guys today. My name is Rebecca Amadi, pronouns she, they, and I am going to just provide an overview. GLEASON has been working on addressing persistent and harassment, bullying, and discrimination faced by LGBTQI plus students for over 3 decades. The Title IX clarifies necessary protections for LGBTQ students and represents a landmark shift in the federal government's commitment to creating safe and inclusive learning environments for all students. Although there's a long history of recognizing the harmful effects of discrimination on the basis of sexual orientation or gender identity, the Title IX update constitutes the first time ever the federal government federal regulation expressly protect LGBTQ plus students from discrimination. So I wanted to quickly just go over some historical precedent. I know Jeanette had laid out a great foundation. I also wanted to bring up a case called Pricewaterhouse v. Hopkins, which is about sex stereotyping. And the court evaluating a Title VII claim on employment law case where a woman was denied a promotion because she did not conform with the expectations of femininity, including in dress, appearance, and behavior. So the court found that sex stereotyping that the plaintiff went through did constitute a violation of federal civil rights laws. And that was upheld. Guidance documents from both the Clinton and Obama administration opened the doors for civil rights investigations to protect the right of LGBTQ students based off of that case, about the sex stereotyping case. So going into 2020, we see Bostock v. Clayton County, where the Supreme Court ruled and stated explicitly that sexual orientation and gender identity is encompassed within the non-discrimination protections. Like in Hopkins, Bostock was a Title VII case related to employment. However, both Title VII and Title IX are drafted similarly, and there's a long history of sharing a legal analysis between the two statutes. In 2021, the Biden administration worked across federal agencies to implement the Bostock analysis in the statutes relating to sex discrimination. So the first notice from the Department of Education for 2021 was the first attempt to clarify that what the court ruled in Bostock applies to Title IX and applies to other sex discrimination statutes. So, what is explicitly in the new Title IX rule for LGBTQ plus students? We have first and foremost enumeration, which is very important. That is codifying sexual orientation, gender identity, sex characteristics, and sex stereotypes under sex-based discrimination. That protects LGBTQ plus students. You have clearly sexual orientation and gender identity, but also sex characteristics, which is protections for intersex students, which we have not seen before. So it's it's great that they made that explicit for a wide range of LGBTQ plus identities. According to GLSEN's 2021 National School Climate Survey, 83% of LGBTQ youth reported experienced harassment or assault in K-12 schools, compared to LGBTQ students who did not experience discrimination or harassment in schools. Those who experienced such discrimination and victimization were 3 times as likely to have missed school in the past month because of feeling unsafe or uncomfortable, reported lower GPAs, lower self-esteem, higher levels of depression, higher rates of school discipline. So we're seeing a clear need for enumerated protections for LGBTQ plus students. We also see that such enumeration is actually also uplifted by the CDC in their Youth Risk Behavioral Survey, the YRBS, which I'm sure many of you are familiar with. They say that LGBTQ protections for LGBTQ students that are enumerated actually improve school safety for all students. So the enumeration piece under Title IX will be beneficial for not just LGBTQ students, but any student looking for a safe and inclusive environment. So we're very glad to see that. In addition, we also know that we also hope that Title IX will help with victimization. As we know right now, 62% of LGBTQ plus students who experience victimization never report the incident. Many said that over 70% said that they did not report because their school response would be ineffective. 60% complained that they were ignored. 16% were told to modify their behavior to avoid victimization in the future, and then 7% were actually disciplined themselves. So we know that Title IX protects against retaliation, protects against non-response from school administrations. So all of these things are very pointed concerns for LGBTQ youth that are addressed under Title IX. Additionally, the second part of the Title IX rule clarifies things on sex-separated spaces and facilities. We know that the general Title IX rule limits separating students on the basis of sex, but for narrow reasons such as facilities, programs, and activities like sex education or locker rooms and bathrooms. So in that regard, the 2024 Title IX updates allows for students to use the facilities and participate in the activities that correspond with their gender identity. We know that 66% of transgender students and 44% of non-binary students face discriminatory school policies that impact their ability to use the restroom. We know that only 37% of transgender and non-binary students go to schools with gender-neutral or all-gender bathrooms. So many students are forced to use bathrooms that are inconsistent with their gender identity. So this new rule says that can no longer happen. We are also seeing already 12 states implement what are called bathroom ban laws where transgender students are not allowed to use the facilities or restrooms that correspond with their gender identity. So Title IX rules as a federal statute preempts state law, so that those rules will have to be found in violation of Title IX now. We've also seen the necessity for these rules as recent cases out of both Oklahoma and Minnesota, where transgender students were assaulted while using bathrooms inconsistent with their gender identity. Um, so it's been very important to have these Title IX updates, which will go into effect August 1st. It's also important to note that what the rule does not uncover or enforce. This rule does not have anything to do with athletics. So that is contrary to what many opponents are saying of the rule, and that the updated rule does not speak to athletics or sports. Nor does it mandate LGBTQ inclusive standards within sports. It is important to note that the same week the Title IX rule was released, the Fourth Circuit ruled that West Virginia's categorical ban on trans participation in sports violated both Title IX and the Equal Protection Clause. There are now separate appellate courts that have questioned the legality of state sports ban, but know that the Title IX this rule does not cover that. And we are expected to see the rule that does include the Title IX sports. That rule should be coming out sometime after the election. We're not entirely sure, but it's still at ORIRA, still receiving comment, and now analyzing the hundreds of thousands of comments that were received on that rule. And I also wanted to talk a little bit about how the rule has been enforced so far, or some examples of the U.S. Department of Education Civil Rights Office enforcement activities around this version of Title IX, or that would be in compliance of Title IX. So what enforcement may look like going forward. In 2022, a Pennsylvania school district was investigated for sex distinctions in their dress code when a boy was disciplined for wearing an earring. This case shows the importance of adopting gender-neutral policies in most instances, while also demonstrating how clear protections around sex stereotypes can also support students in their gender expression. In spring 2023, a Georgia school district was investigated for failing to respond to statements made by school board officials around book banning and the removal of books around LGBTQI plus themes. Although Title IX does not address curriculum or available resources, this shows how hostile environments claims can have an impact, especially when the school district fails to respond to students' concerns. So those students, OCR had found that there was a hostile environment created for LGBTQ students because of anti-LGBTQ sentiment at the school. And that was found in violation of federal standards. And then in 2023, two cases, one in Wisconsin and one in California, where a school failed to investigate student complaints about misgendering. Again, the rule does not explicitly address misgendering, and even clarifies that stray remarks do not constitute as harassment. However, it shows that a pattern of harassment and misgendering can constitute as creating a hostile environment that implicate Title IX. So in the example of Wisconsin case, persistent misgendering by peer resulted in a non-binary student being moved to a virtual school, which is again showing how that could be in violation of the new Title IX standards. I also wanted to do a time check. Am I good? Or because I have one or 2 points to continue on. Oh,
You're okay. Go on.
cool. Great. Thank you. Just wanted to be conscious of time.
Sure. Thank you.
Additionally, we have parental rights. Title IX rule neither extends nor restricts parental rights under the Family Education Rights and Privacy Act, known as FERPA. Parents will still be able to access the records of a student if a student officially changes or alters their school record, but administrators can agree to informal processes that affirm the student in the classroom. So things like, so if a student, there is no notification provision, but a parent can still access their child's records and still see if they officially change their name. So students must be made aware of that if they do want to officially change their school records to reflect their gender identity. However, schools are still allowed to take informal routes that which is like respecting a student's pronouns, respecting their name or a nickname that they would like to be called. FERPA also protects students against disclosure without consent in other instances beyond the parent, such as media, to educators, other parents. So a school cannot reveal a student's transgender identity to an inquiring parent or to a teacher who may be curious. The school cannot do that. Still, state and local policies around forced outing and parental rights remains one of the gray zones where the new Title IX rule does not provide greater clarity. So there's still some ambiguity about parental notification and forced outing policies that Title IX does not explicitly cover. So we have next steps. We have litigation efforts to overturn or delay the rule. There's 9 lawsuits from 26 states. 2 injunctions have already been granted in Louisiana, Mississippi, Montana, Idaho, Kentucky, Tennessee, Indiana, Ohio, Virginia, and West Virginia, meaning that the rule has been enjoined. But that means that for all the other states that are not covered or have not been listed, they should still expect to have to abide by what is in Title IX, at the Title IX rule as it stands by August 1st. So that is an important thing. Until we have a national injunction, schools and states should still if their state is not under the lawsuit, so still expect to abide by the Title IX rules. The U.S. Department of Education Office for Civil Rights continues to investigate claims of sex-based discrimination. There is an online intake form and more information available at GLSEN's landing page. And another important thing is that the USED is not only means for students to assert their legal rights. There are often state and local grievance process that students may also assert their rights in court by filing litigation, where we have more information on that on our landing page. Additionally, it's important that to know that Title IX protects both students and educators. So harassment that we've seen LGBTQ educators also face harassment and discrimination while at schools, and that can also contribute to hostile learning environments. And then some model policies and the call for comprehensive guidance in friendly states, and working with friendly school districts to implement model local policies. So that includes 1, updating policies to include sexual orientation, gender identity, statuses under non-discrimination and anti-bullying policies, and removed unnecessary gendered policies such as dress codes, or gendered dress codes rather. Update policies to ensure access to separated spaces consistent with gender identity. And 3, update policies, practices, and systems to ensure student privacy while securing affirmation, including student record policies, and considering the types of data fields and information management systems, and providing training and cultural competent professional development for school staff. So making professional development for staff to know how to address LGBTQ victimization, have a firm understanding of how sexual orientation and gender identity and sex characteristics may be included under new anti-bullying provisions, and what they need to do to follow up on that enumeration. And if the state is not friendly, you can still work with friendly school districts to advance inclusive policy. We want to remind everyone that Title IX is a floor, not a ceiling, and that school districts can go above and beyond what is required by federal law to provide affirming and supportive school environments for LGBTQ youth. And in some places, it may be beneficial to think more broadly about anti-bullying initiatives, so as a means to direct resources to support LGBTQ plus youth. And just making sure I got everything. And yeah, that is the conclusion of Glisten's portion. I know we're going to do questions at the end. Great. Oh, thank you for letting me drone on like that.
Oh, well, thank you for your informative sharing of information. You covered a lot and it was really interesting. I'm looking to see if our next speaker made it. She had a bit of a conflict of schedule.
Shiwali has just joined. Shiwali has just joined.
I will slowly introduce her so she can catch her breath. Hi, Shiwali.
Hi.
Thank you for joining us. I'm going to introduce you. Shiwali Patel is the Director of State and Inclusive Schools and Senior Counsel for the National Women's Law Center. The National Women's Law Center was founded in 1972, the same year as Title IX was passed, and it advocates for rights of women and girls and LGBTQ plus rights through litigation, policy, and culture change initiatives. Shiwali, who formerly worked in the Office for Civil Rights in the Department of Education, will discuss the litigation by 26 states. I think it's still 26. I don't know if each day it seems to grow, and others against the April 2024 Title IX regulations. She will outline likely scenarios for the timing and the implementation of the Title IX rules and suggest what supporters of these rules can be doing. I'm going to turn it over to you, Shiwali. Thanks for joining us.
Thank you so much for having me. Hi, everyone. I am going to, now that you've heard about the Title IX rule, as Jeanette said, I'm going to talk a bit about the legal challenges that the rule is facing, and just some other sorts of challenges that we are seeing that could impact the rule's implementation. So this rule, as you all heard, is very significant. It does so much to support different communities of students, but really all students, but in particular, student survivors of sexual violence, LGBTQI plus students, and pregnant parenting students. And the Biden administration indicated that the rule would be would have to be implemented by August 1st. So that means schools have to be ready to make sure that all their policies reflect the rule, that they're complying with the rule by August 1st, so that when students return to school in the fall, they have these clear set of protections under the Title IX rule. But as we expected, there have been a lot of attacks on this rule. There has been just a lot of disinformation about what it does, attacks by extremist groups that really don't want there to be robust civil rights protections for students, and attacks from, as Jeanette stated, a lot of Republican states. There are 26 states that are involved in lawsuits. So soon after the Title IX rule was finalized at the end of April, I believe, a number of lawsuits were filed almost immediately. There were 11 lawsuits that were filed. 2 have been consolidated, so now there are 9 pending lawsuits. And 7 of those lawsuits have Trump appointees as the judges who are assigned to the cases. You know, we expected that the groups that were going to challenge this rule were going to seek forums, places where they were likely to get a sympathetic judge. So that was not surprising, but for most, vast majority of them to have a Trump appointee is concerning. One has a Clinton appointee and one a Bush appointee. And all of these, oh, let me go back. Some of these lawsuits also include individual students. Some include school districts, groups, organizations. And again, there are a lot of states that are involved in these suits. And they all challenge the LGBTQI plus provisions. I think Rebecca probably covered you know, how comprehensive and important these protections, these rule clarifications are for LGBTQI plus students. So all these lawsuits are challenging those provisions. A few are also challenging the changes in the grievance procedure. So I'm not sure if Karen talked about this, but the protections, the clarifications for student survivors. A sexual assault is key, namely because the Title IX rule removes or gets rid of much of what the Trump administration did in 2020, including by restoring better grievance procedures so that they're less onerous and burdensome for students, right? Students shouldn't have to be subjected to more burdens when they report sexual assault, just because they're reporting sexual assault, which is what the Trump rule imposed. So a few of these lawsuits are challenging the fact that those grievance procedures have become simpler and less hostile to survivors. And then the other part of the rule that you may have heard about that's significant is the impact on pregnant and parenting students, and how, you know, clarifications, how the rule clarifies the types of accommodations, leave, you know, information about their rights that schools have to provide to these groups of students, which also includes students who terminate their pregnancy. So since the regulations first came out on Title IX in 1975, there was always, you know, clear language that Title IX's protections extend to students who terminate their pregnancy, including students who get an abortion. So two of these lawsuits specifically challenge that piece of it, the clarifications around abortion protections. These lawsuits have also sought an injunction, a preliminary injunction, which means that they're asking the court to issue a quicker decision, basically saying that the Department of Ed cannot enforce the rule. And unfortunately, about 2 weeks ago, there have been two decisions that came out, two different lawsuits that did grant them their request for a preliminary injunction. One of them was in Louisiana, and so on June 13th, the judge granted a preliminary injunction that only applies to the states in that lawsuit. That's Louisiana, Mississippi, Montana, and Idaho, saying that those states don't have to comply with the Title IX rule. And then a few days later, on June 17th, a Kentucky judge granted an injunction impacting Tennessee, schools in Tennessee, Indiana, Kentucky, Ohio, Virginia, West Virginia. Now, even though those injunctions have been granted, that doesn't mean the litigation is over. It doesn't mean that schools in those states should stop working towards implementing the rule by August 1st. Because what is likely going to happen, and what actually has already happened, is that these are going to be appealed. And earlier this week, the Department of Justice did file their notice of appeals, basically, you know, asking in a higher level court, an appellate court, to review those decisions in those cases. So the litigation is ongoing, and what we've been telling schools and what, you know, we're saying is that schools should still work towards implementing by August 1st, even if they fall in those states that have that injunction, because an appellate court can undo the injunction. So that's kind of where we are with litigation. There are some groups that are, you know, working on filing amicus briefs. These are briefs that you can file with the court to inform them about the rule. The National Women's Law Center has filed an amicus brief on Friday in the one case that has a Clinton appointee on the issue of access to sex-separated facilities like restrooms and locker rooms, and that, you know, students should be allowed to use the restroom or locker room consistent with their gender identity, which is what we've argued, and to rebut, you know, what the other side has said, which is reliant on a lot of disinformation. claiming that like Title IX does not allow trans students to access the bathrooms that are consistent with their gender identity. We will be planning to file an amicus brief in the other lawsuits once they're on appeal. So once these decisions for an injunction come out, then they're on appeal, and we're going to be seeking sign-on. So stay tuned for that, for an opportunity for your organization to join that. So in addition to the litigation, that's kind of one line of attack I see. The other is just, again, focused on the states. We've seen Republican governors advising schools to not comply with the Title IX rule. Like there have been state departments of education. We saw a notice last week from Texas, where the Texas State Department of Education sent out a notice to its institutions saying that they should not comply with the rule by August 1st. Essentially what they're doing is they're telling their institutions to violate federal civil rights law and putting them at risk of losing their federal funding. Because if they violate the regulations and OCR, the Department of Ed, then investigates them, they can lose their federal money. And so we, along with GLSEN, have been leading a sign-on letter, which we sent around to some listservs, and I can add the link in the chat. But we have a sign-on letter that we are urging groups that focus on education, civil rights, gender justice to join, urging all school and university administrators to swiftly implement the rule by August 1st to counter what these Republican governors are instructing them. And it hasn't just been Republican governors. There have been some extremist, like far-right organizations that are sending out letters to institutions telling them not to comply. So we have our counter letters telling them that they should comply. This is why the rule is important. Even if there's litigation, it doesn't mean that these schools don't have to comply. They're still risking federal money. And I'll put a link to that in here for any of your organizations in the chat. Can I put it in the chat, Jeanette? Okay.
Yes, go ahead. You can put it in the chat
Okay, so that's for organizations, and you can see the link there. You can read the whole letter in the link. And then lastly, the other line of attack. So you have the litigation, you have these governors that are instructing schools to violate federal civil rights law, and then you have Republican members of Congress who are using something called the Congressional Review Act, or CRA for short, to stop the rule. What the CRA is, or what the Congressional Review Act is a tool for Congress to disapprove of a rule, of a regulation that they don't like. And the way they do this is the House and the Senate introduce a resolution, and by a simple majority vote, they can vote to disapprove of the rule, and then it goes to the president. The president can veto it, or they could agree then and sign it, they could then agree to remove the rule. And Congress has 60 congressional calendar days to vote on this Congressional Review Act resolution. Now, that really becomes an issue towards the end of an administration, because the 60 days can continue into a new Congress. And when you're at the end of a presidential administration, you don't know what's going to happen with the election. There could always be the chance then that a new Congress could vote on the CRA, and the different president can then decide whether or not to veto that resolution. In this case, we're safe. The Biden administration released this rule before that 60-day cutoff, so that, whatever CRA resolution is passed, and it likely will be, at least, coming out of the House, that Biden would veto it, because he's not going to disapprove of his own regulation. But even still, we want to make sure that there's as little support on the Hill, especially among Dems, for this CRA. And so the House and the Senate have already introduced their resolutions. And not only is it to disapprove of a rule, but if a CRA is successful, then it would prohibit a future administration from releasing a substantially similar rule. So that would really tie the hands, if they were successful, of an administration then releasing a similar rule in the future that would, clarify these protections, which is very harmful. And in the House, the Education, the Workforce Committee already marked up and they voted out the House CRA. So we're expecting a House floor vote maybe in the next few weeks. And then the Senate CRA resolution was introduced after the House. So after the House resolution was introduced. So our organization, along with GLSEN and Human Rights Campaign, put together a sign-on letter opposing the Congressional Review Act resolution. There is still, we had reopened it after the Senate CRA resolution was filed. And I'm going to put a link to that in the chat. This is open to organizations. We would really love to show broad support to members of Congress for the Title IX rule in opposition to the CRA. And I will pause there to see if there are any questions or follow-up needed.
Please put your questions in the chat. We've opened that up for everyone, and then we'll move on to our next speaker.
Let me unmute. Okay. Thank you, Shiwali. And I'm sure there will be some questions, and we'll follow that up at the end of all presentations. Our next speaker is Karen Truszkowski, who's representing Stop Sexual Assault in Schools, SSAIS. She is an SSAIS officer and attorney who represents K through 12 and higher education Title IX plaintiffs. She will discuss how the Title IX 2020 regulations were changed in the 2024, especially relating to the procedures to be used in handling complaints of sexual assault and harassment, and to provide more explicit protections and support to pregnant and parenting students. Karen will also discuss the specific roles of the Title IX coordinators and their designees, such as investigators, decision makers, appeals officers, and informal resolution facilitators, and how they are supposed to work with all involved. I see that the slides, Karen's slides have been posted. I think you'll find them very informative and useful, and I'm turning this over to Karen.
Thank you, Jeanette. Thank you, everyone, for inviting me here today. I do feel like a little bit of a lightweight with all these other very accomplished people, so I do appreciate it. First, I want to tell you, I am not a Washington, D.C. policy wonk. I am not a civil rights attorney for the Department of Justice. I represent the little kids and the young women and young men that have been wronged by their school. And I'm in kind of, I would say in the trenches, basically, litigating all of the issues that you just heard about. There are some very critical changes in the 2024 rule that I think, I mean, there's so many changes, we can't go over them in an hour. I went through the rule and picked out the few that I think most everyday Joe and Sally on the street need to know. And especially people that aren't attorneys, parents, and the kids themselves. So I'm going to go through a few of those critical points. But before I get to that, I want to say that I've had many, many people calling me since the new rule was issued, asking me to go on board with whatever their idea is about what the rule means. I've actually been asked to represent some organizations, which I'm not going to name, that wanted me to be on their side, meaning we ignore transgender children. We don't let them identify that the way that they feel that they are identifying. I'm sure that all of you can probably figure out that that is not where I stand or where I land. So I haven't participated in any of those discussions. The but they're certainly out there. And it reminded me as I was listening to everyone this afternoon, when I was in 3rd grade, which I'll age myself and say was about 1970, I can remember being in 3rd grade and wondering why I couldn't wear a pair of pants to school. And I asked my mom, why can't I wear pants to school? The boys are wearing them, so why can't I? And I did it. Got in big trouble. But since then, obviously things have changed, and we can all wear pants to school if we want to. And that's why I'm hopeful that as time goes by, we'll accept transgender kids, that it's not going to be an issue, just like it was an issue for me trying to wear pants in 3rd grade. So having said all of that, there's also one thing I want to talk about briefly that is not part of the Title IX rule, but it definitely affects anyone that has been wounded or hurt in a school. And that is a Supreme Court decision. It's the Cummings decision. And I'm not going to go into a big, Law 101, but I just want to say that the Supreme Court ruled in the Cummings decision that there are no emotional distress damages available. It doesn't specifically say Title IX, but that is the way that it's being applied. And what does this mean for all of you, all of us? It means that when I have a child that has been persecuted, bullied, ignored, has extreme emotional distress, will never be the same. And according to the Supreme Court under Title IX, they are not entitled to any emotional distress damages. That has pretty much obliterated, it's done away with Title IX litigation that helps kids. So aside from this 2024 rule, we have to be conscientious about what our Supreme Court is doing. And again, I'm not going to get into a big political discussion, but that has decimated damages for kids and young adults. Okay, so the provisions in the new rule that I think are most important, and these are not in any particular order of importance, but first of all, I am grateful that we have a new a new definition of what constitutes harassment. The 2020 rule narrowed it quite a bit, and the 2024 rule has now expanded it. And you can see on my slide there that it has changed to severe or pervasive. In the 2020 rule, it was severe and pervasive. So it's a little bit of a nuance between and or, but it makes a huge difference when we are litigating these cases, because when you have an and, it's a high burden. When you have an or, we can show severe and it may not be pervasive, or we can show pervasive and it might not be that severe. So this is a very critical change. And it also goes on to say, if it denies or limits access to education, also very important distinction. And it does expand what we can recover for kids. The other change in the 2020 rule, off-campus harassment, anything that didn't happen in a school building or on school property, was not considered under the jurisdiction of the school under Title IX. That has been changed. And this is I will tell you, as a litigator, I have litigated this issue probably more than any other issue I've had. If off-campus harassment creates a hostile environment in the school, it is covered by Title IX, and it doesn't matter where it happened, if it's creating a hostile environment. And why is this important? Well, especially now when we have deep fake imagery, we have artificial intelligence, we have all of these things, online harassment, and schools would chronically say, we don't have any obligation to deal with that because it happened off campus, but it has a huge impact on the campus itself. So that is a very critical change. Notice requirements. This has always been an issue. Who has to report? Who is a mandatory reporter in a school district or a university? And the new rule basically says all employees must report any indicia of what they may see as sexual harassment, sexual assault, bullying based on gender, anything. They are required to report it to the Title IX coordinator. And it is not the employee's job, and I'm talking about everyone from the janitor up to the school superintendent. It is not their job to decide what constitutes sexual harassment. If they have a reasonable belief of it and information, they have to report it to the Title IX coordinator. And it's the coordinator's job to take a look and decide, does this fall under Title IX? Does this fall under sexual harassment? And I implore teachers, administrators, err on the side of caution and report. Don't ever, oh, that doesn't seem like sexual harassment. I'm not going to say anything. Not your job. Also in higher ed, all employees must report to the Title IX coordinator. Confidential employees, and what do I mean by confidential? Certain counselors, clergy that have a duty of confidentiality, they can be exempt from that requirement if they are put forth as confidential employees, particularly school counselors, people like that. The next important point, supportive measures. And I have to say that there is a word missing in this the sentence, and I apologize for that. Supportive measures are mandatory regardless of whether there is a complaint that goes forward, or if it's dismissed, or if a student chooses not to move forward with a complaint. The school still has to give them supportive measures. This is also an issue that I have litigated many, many times. I've heard superintendents and principals tell me, well, they didn't want to do anything about it, so we don't have to accommodate their class schedule. We don't need to keep the bully out of the lunchroom where they're eating lunch. Well, yes, you do. Because many students, just like our general population, are afraid to go forward with the complaints, but that doesn't mean that they don't still need support. That's a very critical point. The next important point, informal resolution is now afforded under any situation, with the exception of employee-student harassment. In that instance, informal resolution is not an option. And I don't think I need to explain why that is. When you have an employee-student relationship, the power differential does just not afford for informal resolution, and you have to have an outside decision maker. One of the most critical, and another one that I'm very happy to see, is we don't have any more cross-examination, particularly at the post-secondary level. We don't have cross-examination of either the respondent or the complainant. I find, or have found, that cross-examination, even in a non-criminal proceeding, which Title IX is not a criminal proceeding, is as much, if not more, traumatizing than the actual harassment or assault itself. The 2024 rule has eliminated that. And I, for one, am very grateful for that. Appeals. The 2024 rule basically says, if you're going to give appeal rights to somebody for race discrimination, disability discrimination, they have to have the same appeal right under Title IX for gender-based discrimination. And also an issue I've litigated many times, that schools were not offering appeals for Title IX gender-based harassment, but they would offer it for kids that had been discriminated based on race, based on disability, based on religion. So they all have to be on the same playing field, regardless of what the basis is for the discrimination. Training, also important. The 2024 rule is very explicit that all employees must be trained to identify potential sexual harassment and how to address it. And the basic premise there is, if it walks like a duck and it quacks like a duck, you need to report it. Meaning, if it seems like there's potentially harassment, report it and let the trained Title IX coordinator make the determination. Aside from the general employees needing training, the 2024 rule also says that Title IX coordinators, investigators, resolution facilitators, all of those individuals need additional training to learn, how do you conduct an investigation? How do you interview kids and be trauma informed? How do you make decisions? How do you decide about who is a credible witness and who is not? And how do you weigh the evidence? All those things are additional training for people that are designated as the Title IX coordinator, investigator, etc. Something that I have found over and over again. Uh-oh, can you see me?
Yes, we can.
Okay, I'm sorry, we're having very bad storms here, so my apologies. And now I lost my train of thought. my apologies again. What I see over and over again, and I'm hoping this will change, is that we'll have someone in a school district that's a Title IX coordinator and doesn't even know it. They don't know that they've been assigned that role. So we need to focus on giving schools room to train people. Sometimes the training that I see is a half-hour PowerPoint that's written by some, and I say this respectfully, some policy wonk in a big firm. It doesn't, and they don't talk about what I'm talking about. They talk about the rules and the regulations. The average teacher doesn't need to hear that. They need to hear, here's what you need to watch out for. If Johnny tells you this, you need to go talk to the Title IX coordinator. If you're a high school teacher and you have a young woman in your class that somebody said, hey, I think she's pregnant, you need to know that you need to advise that young woman. You can go and talk to the Title IX coordinator, and here's how they can help you. And those are the things that we need to support our educators on. Education now, with everything that they have to teach and in all the regulations, everything, it's overwhelming. And which one do they pick? It is overwhelming. And we need to be more supportive of our teachers and our administration. Absolutely. A lot of people think I'm anti-education or anti-teacher. I am not. I was a teacher myself. So I understand why it's so difficult, because teachers, for the most part, don't know what they're supposed to be doing. I think those are the main points. Some of the other things I was going to talk about have already been discussed. What constitutes sex discrimination under the LGBTQ, and finally, transgender students. I am the first to admit that it's a difficult situation. What do we do with transgender kids. We have a school that's been built in the 1950s. They have 2 bathrooms. What are they supposed to do? Retrofit it? It is a challenge. But just like when I wanted to wear pants to school, we can figure out a way to work around it. And the big stereotype, of course, I always hear is I don't want my daughter sharing a bathroom with a man or a young man that decides they want to be a woman. That's a threat. They're going to be raped, etc. That's what I hear consistently.
Mhm.
And we have to work to change that narrative. So that's my short list. There's a much longer list, but those are the important things that I think people really need to know right now. So thank you, everybody. And I will, I think my time is probably up. My apologies if I went over. Oh, yes. And I also want to say I am a director for Stop Sexual Assault in Schools, which is an amazing organization that provides education and support to families and children across the United States. And I urge any of you, if you have questions or issues, contact SSAIS because they're a fabulous resource. Thank you.
Yes, thank you, Karen. Very, very nice. I enjoyed your slides and your presentation very much. I'm going to open this up for questions.
Jeanette, we have a question. It came from Karen Humphrey, and I sent it to Karen Truszkowski in the chat so that she can look at it and answer, but the other respondents the other speakers may also want to.
Can you go ahead and read it?
Oh, sure. This is an enormously fascinating and needed enlightenment on the new regs. Notwithstanding the challenges to this rule, is anybody aware of any school district or other federally funded entity actually losing their federal funding over Title IX violations? I'm aware there have been many corrective action plans issued which sometimes lead to good outcomes, but I'm sure many of these have failed. Has the Department of Education ever actually defunded any institution or school district, and should it have?
I can answer that. No, not that I'm aware of. And
actually, I can answer that.
Oh, I'm sorry, Jeanette, go ahead.
Yeah.
You probably know better than me.
Back in the day, and I'm talking in the 70s, we defunded the Flint School District. Karen, that's in Michigan.
I know.
And that's the only one. We used to have a song in OCR that was the theme song about negotiate, negotiate, forever negotiate, never, never terminate. Anyway, you're right. The terminating federal funds to students, which denies the education whose purpose our civil rights laws are meant to provide, is what we would call going too far, unless if we could get resolution.
We certainly see large fines assigned.
Thank you.
More so to universities and colleges than K through 12, but Michigan State was assigned a major fine, as I believe Penn State was as well. So they do have the ability to hit them in their pocketbook, so to speak. But I think as a general rule, most school administrators know that the likelihood of them losing their funding is slim to none. So that doesn't have a lot of teeth. But on the other hand, I wouldn't want a school district to lose its funding because obviously if they're struggling, they need funding. So it's kind of a catch-22. I see another question.
Yeah, there is.
Sorry,
Holly Knox.
Let's go to Shiwali. She wanted to add to the answer, I think.
Yeah, just to clarify the fines, like the Clery Act fines, Karen, you mean? So the fines have come out of like a different office at the Department of Ed, and it's run through their Office of Financial Aid, which is the Clery Act. So that law is more focused on like consumer protection And
Right.
it's not, they don't enforce Title IX, but the Clery Act only applies to higher ed institutions, and it does require, kind of consistent with Title IX in some ways, like schools to have policies addressing sexual violence, dating violence, domestic violence, and sex-based stalking. It doesn't address all of sexual harassment. But yes, like Clery allows the Department of Ed to issue fines. So where there have been like concurrent Clery investigations with Title IX, like at Michigan State University, you saw through the Clery investigation, they were fined quite significantly, but OCR doesn't have that ability to issue fines. It is something that some of us have been thinking about, advocating for through other federal legislation.
One additional comment: the termination of federal funds is one option. The other option is to refer to the Department of Justice for specific performance. And based on the current leadership in the Department of Justice, I get the sense that they are more willing to accept these referrals. We had a bit of issues in the earlier days, but there is another alternative. Fines, termination, referral to justice for specific performance.
And I think protecting the ability of children to have a decent school funding is one thing. And I hope it would never be necessary, but I just wondered, that's the only threat that we seem to hold over their heads. And it's good to know there are other options that are short of that.
There's one, I'm sorry, Karen. Yeah, I'll wait.
No, do you want me to answer? It looks like Holly and Connie asked
Holly.
me.
Yeah, why don't you take Holly's question? What kind of
Okay.
discrimination do you find most common in schools and colleges today, Karen?
That's a tough one to answer. There's so many.
Yeah.
The common myths, the urban legends. She lied. She made it up.
Yeah.
That's probably one of the biggest, especially, well, actually in K through 12 and in the universities. She made it up. She lied. And as many of you may know, false reports of rape and sexual assault, percentage-wise, are not any different than any other crime.
Right.
Carjacking, robbery, anything like that. So we're constantly arguing that's discrimination. Right there, they don't believe women when they say that they've been assaulted, and boys too, which is part of the reason that boys don't report at all, basically, because if they are assaulted by another boy, nobody wants to believe that, and that's just boys being boys. The other, probably the big thing I see at university level is kids that have been drinking and got themselves in trouble and have been raped, assaulted, and it's okay then that the boy did something to her because she was drunk. That's a big basis for discrimination. But in K through 12, most people don't want to believe it happens in K through 12. So I've heard it 1,000 times. I've had many cases with young women that have been assaulted on school grounds and have been suspended or even expelled for having sexual activity on school grounds, even if they didn't consent. So it doesn't happen to boys as much. And don't get me wrong, I have represented lots of boys too. They have the same issues, but unfortunately, chronically, it's young women. So that's probably the biggest things that I see. Did that answer your question, Karen? And who? Okay.
Holly Knox asked that.
Oh, okay.
We have another question from Lindsay Abernathy, and either you, Karen, or Shiwali, what happens if the school is referred to the Department of Justice? And she added on, or what could happen if the school is referred to DOJ? So either one of you can respond.
Well, I hope I'm understanding the question. If someone files a complaint with the Office of Civil Rights, is that what you're asking? What happens?
Thank you. I was asking, we're saying that there's the other option of referring this, maybe I misunderstood, but referring the school to the Department of Justice. Oh, and I see that you're saying they could sue.
Yeah, there's an, yes, and thank you, Shiwali. There is an option of a private course of action, which is what I do, not regularly, but as a last resort. But a complaint filed with OCR the OCR first will determine if they have jurisdiction, and then they will contact the school district, inform them of the allegations that have been levied against them by student or students. And then they typically offer some kind of an alternative dispute resolution, which I encourage if that's available. And if the school district or the family, the students don't want to do that, then OCR has the option of proceeding with an investigation and then making a determination if there have been any violations made.
Shiwali, did you want to add anything to that?
No, I've been answering questions in the chat if it's helpful about like the
Oh,
implementation
great.
date.
Wonderful.
I'm also going to share a link if it helps to like a brief kind of summary and chart that NWLC developed to kind of compare pre-Title IX rule to where we're at right now. I think the rule itself is it's gigantic. So our hope is that this sort of summary will be more digestible for folks who aren't in the weeds. So I'm going to put a link to that in the chat as well.
Oh, great. That chart is very, very helpful. Nico Feliciano has a question to everyone. Will every school district be mandated to develop policies or codes of conduct in alignment with the Title IX changes? I'm thinking specifically of those related to sexuality and gender.
I know Shiwali answered in the chat, but yes, basically, you have not creating necessarily new rules, but like policies that address like the enumeration. GLSEN suggests is that for especially particularly in states that are friendly, enumerating policies of in anti-bullying statutes, which some states already have, include sexual orientation and gender identity explicitly under as protected in non-discrimination and anti-bullying policies. Our GLSEN Navigator NAV actually has, I believe, it's around 20, but I'm not 100% sure. But again, as Shiwali said, if it's not schools, administrations should act as if August 1st, the national rule will be the law of the land, even with the lawsuits that are pending and some of the injunctions of those various states that had listed previously. But any one that's telling schools not to do the enforcement or they don't have to will be found in violation of federal law on August 1st.
Great, thanks. Shiwali, do you have anything to add?
Yeah, I was just going to add that, so just to clarify, because I put this in the chat too, that so there's the Title IX regulations, right? And then that's separate from private litigation. So like, even if the school is, let's say they have a preliminary injunction, and Virginia, I think, is one of the states that has a preliminary injunction, right? They're in the Fourth Circuit, and the Fourth Circuit has already kind of decided this issue around access to restrooms for trans kids, right? In the Gavin Grimm case. So I think these school districts, even if they don't believe that they need to comply with the Title IX regulations or being urged not to, or maybe the injunction is still in place by August 1st, they could still be subjected to a private lawsuit under Title IX that is based off of court decisions recognizing that Title IX does provide these broad protections. And so it's, there's that kind of other threat of litigation outside of the pulling of federal funding by not complying with the regulations.
All right, thank you. Any other comments or questions?
This is Karen from California. Just want to mention that my friend Sue Klein and a few others have been pushing for years to require school districts, K-12 districts, to have a coordinator in every school, not just at the district level. And even at the district level, sometimes these are people that Title IX is not their full job, even if it's a big school district. So, and it seems to me that there's also a great need for funding and support for training and ongoing refresher training. I mean, everybody needs refresher training. And it seems to me a lot of the federal funding that used to support that has sort of dried up. And state leadership has dried up, I think, in some places. So I just wanted to say, I'm interested in whether any of you think that that suggestion, both more coordinators designated and connected to their schools and more training, would be able to not only prevent discrimination, but get it resolved more quickly. I've been supportive of Sue's effort, but it's a hard effort to get any policymakers to consider.
Well, I
Sue?
agree with that wholeheartedly.
Sue, did you have a comment to make?
Sure. I'd like to note that in the new Title IX regulations, they don't require a Title IX coordinator at each K through 12 elementary school, as I had recommended, but they do require that each school district at the K
Sue,
through 12.
we can't hear you. Sue?
Okay. Can you hear me now?
Yeah, now we can hear you. You're back.
Sorry, I'll hold the mic closer. I was saying that the new regulations don't require a Title IX coordinator at each individual K through 12 school district, or each separate school, for example, a school of education in each university, but they do require a head person, for example, a school district coordinator, and the school district coordinators are empowered to designate separate coordinators to assist them, as well as other school staff that they need to help implement and train people in Title IX. So it puts a lot more burden and power in the actual confirmed school district coordinator, and allows a lot of flexibility for more school districts to implement and assign more people to have specific Title IX responsibilities. And that needs to be heavily attended to make the whole system work better.
Thank you, Sue.
And
Great.
I'd also like to comment before we close this wonderful presentation. Thank you so much to all of the presenters, and to Jeanette for moderating and leading the way, and all the history and work that she's put in through the years. Thank you. I think this was a fantastic meeting.